I'd like to call the Monday, July 16, 2018 Oakwood City Council meeting to order. Would you please rise and join me with the pledge to the flag?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
May I have a roll call, please, Lori?
Mayor Duncan.
Here.
Vice Mayor Byington.
Here.
Mr. Stevens.
Here.
Mrs. Hilton. Here. Mr. Epley.
Here.
And may I have a report on our June 4 regular session, work session, and executive session, Mrs. Hilton?
Yes, Your Honor. I've reviewed the minutes from all three of those meetings. I found them to be correct and complete, and therefore I move that they be adopted as written.
Do I have a second?
Second.
All those in favor signify by saying aye.
Aye.
Thank you, so ordered. We have no status reports this evening, but we do have a visitor, a very special visitor tonight. We have the County Recorder's Office, Brandon McLean, who wishes to address council. Brandon, welcome.
Thank you, Mayor, respective members of council, and members of the general public city of Oakwood. To all of you, I say good evening. My name is Brandon McLean. I'm your Montgomery County Recorder. You know, it's been said that if something affects one of us, some of us, then ultimately it affects us all. The very truth and meaning of those words is what brings me before you here today to discuss something that has touched every citizen, touched every city, every roadway, every boundary, every neighborhood, every village, every township, every roadway, every underpass here in Montgomery County. Unfortunately, that's something that has affected us all, is property deed fraud. I'm here to talk to you today about what steps you can take to proactively combat property fraud and protect your most valuable investment, that being your home. As an attorney, I encountered individuals who had been defrauded and had their home ownership interests be extinguished or negatively impacted by the perpetration of fraud by individuals who wish to scheme them. As a member of the court, I served as a magistrate and acting judge in Dayton Municipal Court, dealt with real estate transaction cases, landlord-tenant matters, land sale contracts, and I would have individuals enter into my courtroom who had had their home ownership interests taken away from them. When I became the Montgomery County Recorder, my first 60 days of administration, I implemented a system, a free, proactive system to allow the protection of our homes in a proactive as opposed to reactive manner. That system is called the Fraud Alert Notification System, or as I like to call it, the FAN system. So, what is the FAN system? FAN system is a voluntary enrollment, free system. It did not cost 1 cent of taxpayer dollar to create, does not cost 1 cent for our property owners to sign up for. Upon an individual becoming voluntarily enrolled in the Fraud Alert Notification System, or as I call it, the FAN system, it would allow a property owner to receive notification upon the recording of a deed, a mortgage, a lien, or other type of recorded document that may potentially affect their ownership interests. This notification will come by way of either email, correspondence, or both if you so chose. This becomes very important when we talk about the steps that one must take to properly combat property fraud, specifically property deed fraud. Because when we talk about your actual protection, time is either your best friend or your worst enemy. Because if you cannot adequately pinpoint when fraud occurs, you are essentially left chasing a ghost. So what is my jurisdiction here in Montgomery County? Approximately, I'm the overseer of 254,000 parcel properties. Of that, approximately 61% equate for home ownership, and of that, about 84 for residential. Now, of that 61 that are home ownership, you have roughly about 23% that are investors. And when we talk about who is most likely targeted to be a victim for property deed fraud, we're talking about two major groups. We're talking about either our investors or we're talking about our seniors. And there's a lot of overlap because of retirement in both those groups. Our investors, because they have one set of eyes, but yet they are trying to accumulate and amass more, whether that is for investment purposes. Either way, they are attempting to try to invest in our community and to gain wealth or accumulate some type of capital. And then obviously we have our seniors who are also a big vulnerable group of property deed fraud because they also have one set of eyes, but as they slow down, the world seems to speed up. And so when we talk about the groups that are negatively impacted, unfortunately, those two most groups are the ones that are most likely targeted. So how real is this circumstance of property deed fraud? Well, I've told you that when I served as an attorney, I encountered individuals in my practice who had actually been victims of property deed fraud. When I served as a member of the court, as a magistrate and acting judge, I had individuals who entered into my courtroom who had been victims of property deed fraud. And unfortunately, from my experiences even beyond, I can attest that this issue of property deed fraud here in Montgomery County is not only becoming more prevalent and escalating, but unfortunately it's very real. In fact, since 2017, there have been nearly 12 instances of property deed fraud that have had to be referred for criminal investigation here in Montgomery County. Just approximately a week ago, there was an individual that was indicted on 25 counts of property deed fraud here within our borders. And I'm sad to say that there were instances of property deed fraud that touched every corner, every border, every boundary of our Montgomery County. When you look at now us being in July of 2018, and these statistics began to be compiled in January of 2017, that is on average one individual per month that have had their ownership interests concerning their homes be negatively impacted, extinguished, or questioned. That is 12 too many. And that is if I don't even count in the individual who was just indicted a week ago. We have to do more. And so I've been making sure since I've been the Montgomery County Recorder that we do more. I've been going to our respective cities, our townships, our villages, our neighborhood association meetings, and talking to our community, talking to our neighbors, talking to our seniors, and anyone else that can listen about what steps that need to be taken, should be taken to protect your home. Because our home is the best indicator of what we spend our time away from our loved ones doing. It's why we wake up early in the morning. It's why we go home late at night. It's why we spend time away from our family. It's why we spend time away from our loved ones and our children. It's so we can accumulate something to have to pass along to our loved ones and kin. And so when we talk about the importance of home ownership, that is something that is of the utmost importance that needs to be protected. So how would you register for my free fraud alert notification system? You can do it online at my website, which is www.mcrecorder.org. You can also visit my office. I am located on the 5th floor of the County Administration Building. The address is 451 West 3rd Street, Dayton, Ohio, 45402. Or you can give me a call. As you can see, I'm not someone who's short for words. My telephone number is 937-225-4275. With that being said, Mayor, respective members of council, and general public, I'll open the floor for questions.
Are there any questions for our new county recorder?
Yeah, so just curiosity, so they're laid out literally in layman's terms. They steal the deed, put their name on the deed. They're trying to just steal property by putting their name on the deed? Is this what they're doing here with the?
Yes, Councilman, what I generally see this way of property deed fraud transpire is by forgery. That forgery, in my opinion, has a breakdown of a few spots, but most notably is because either there's a notary that's either perpetrating the fraud along with this individual who's a forger, or it's a notary who just doesn't follow simple protocol and procedure. At any rate, there's a breakdown in the system where either we have a forgery straight out right, or we have a notary that's on the inside.
Okay.
And because of that, unfortunately, anyone, anywhere, at any time can be a victim of property deed fraud. This issue of property deed fraud has nothing to do with something that an individual property owner does or does not do. And that is why it's so important, it's vital, that as property owners, we be proactive as opposed to reactive. Sign up for free fraud alert notification system to make sure that we have eyes on our home when we cannot.
Very good.
And
Other
that's what
questions?
it'll do.
Oh, I'm sorry.
No, that's okay, but that's what this will do if we sign up for the fan system. We're registering all of our information and emails, and if someone, tagged to our address? Is that how it works, in our name? And because we'll go in there and see our information, assuming I haven't been, my deed is still good. Yeah, I haven't been hacked. That's what I'm saying. So it'll give us a notification. It's a fraud alert notification based on just the deed, right?
Yes, Councilman, essentially the way my system works is that it uses triangulation. So essentially the best indication of your property is your parcel ID number, cross-reference with your legal description, and then a third cross-reference of your acreage. That is essentially the same thing as a fingerprint. There are other systems that are similar in the market that go through third parties and charge money. The system that I've implemented, in my opinion, is the most accurate on the market because we use triangulation to get something that is a lot more accurate than a name. Because the reality of it is, if your name's something like John Smith or Chris Johnson or something very, just generic, then unfortunately, anytime an individual does something with that property, if we just did by name, you receive alerts for every Chris Johnson. And so it would essentially weaken the ability to actually warn the person because they wouldn't know if it was sincere or not. And so I'm proud of the work that we've been able to do to get something more accurate, to get something to protect our community a little bit better.
Excellent. Great. Thank you.
Thank you, Council.
Other questions? Okay. Just like for the folks at home to know that Brandon was recently appointed to the County Recorder's Office after the unfortunate passing away of Willis Blacksher. And we appreciate your efforts on this, and we will make sure that if there's anything that we can do to pass this word along to our residents, we will be happy to do that.
All right. Thank you very much, Mayor.
And we appreciate you coming.
Thank you much. And I actually have a second program that I'm going to be discussing here tonight
Okay.
as well.
Okay. You should have never asked us for questions first.
I didn't want to wait till the end.
That's
'cause I was like,
okay. Oh, yes, this is the one you talked to Norbert and I at the VA. Yeah.
Yes, yes. Second program that I will be introducing in my administration will be for our veterans. I'm also a veteran, and I believe that we have to make sure we give our best to our best. The Veteran Identification Card program that I will be implementing that will be released, I anticipate in late August, early September, we begin to have the conversation where we need to discuss things as a community, as a county, as a state, as a country, about what it means to stabilize our vulnerable group, that being our veterans, and make sure that we serve our veterans as they have so faithfully served us. So what is the cost of this program? For our veterans, the cost of this identification card will be free. It will be free for any eligible veteran. And under Ohio law, an eligible veteran has been defined to be a veteran that receives a discharge that is, by definition, anything aside from other than dishonorable. And so any veteran that receives a discharge that is anything aside from dishonorable would, on its face, meet the criteria to be eligible for a veteran identification card. What are some of the benefits of this veteran identification card? Obviously, you hear me calling it an identification card because it is, but it's so much more than just an identification card. It also is a momentum of generosity that denotes a veteran's honorable service to our great nation. It also will replace the pocket DD-214, which is very important when we look at our close proximity to Wright Pat and the fact that within our midst in our county, I'm sad to say, we have had veterans who have missed out on the ultimate right upon their death, that being a proper military burial. That never should happen. And this identification card offers stabilization to ensure that those things don't happen. In addition, it will also break down some of the barriers that have traditionally separated our veterans from great community services, whether that be for assistance for health care, VA home loan benefits, proof of military service, and a host of other benefits as well. I'm proud to say that this card will also identify the branch of service and the dates of service as well. That becomes very important, especially when we look at our older senior veterans who still may be carrying the pocket DD-214. My fear is that when they pass away, if they don't have a proper DD-214, which for our veterans is their discharge documents, and they don't have a military ID, then what other valid form of governmental proof of service do they have? And for a lot of our veterans, they don't have anything aside from that. There isn't anything aside from that. And so this card offers stabilization to a group that unfortunately has went for too long without it. So what is required for you to obtain a veterans identification card? Well, you do have to record your DD-214. And for our military veterans, that is your discharge document. You also would have to provide 2 valid forms of identification. You'll see those identified here on the form here. With that being said, I'll open the floor back up for questions.
questions for her?
Seems like a good program.
Yeah, it's a very good program. Is this something that you're encouraging veterans to come down to your office to do?
Yes, Councilman, the program, we will be officially releasing the program, I anticipate, the latter part of August, the first week of September. My staff was just trained on it about a week ago, and we're still making sure that we can roll, because we do have within Montgomery County approximately about 42,000 veterans, and so we want to make sure that we are able and capable to handle all facets.
And the plan is to do it at your office, probably not set up to do it mobily or outside of your office?
No, it will be actually offered in the office. We will actually be offering you to be able to obtain a veteran identification card. A program will actually be offered on our side with the Copy Center.
Okay. I got ideas running through my head on where we could do this. and
Mobile
I'm
VA
going to be giving you a call.
Please do.
We'll talk. I got a few ideas.
Yes, sir.
Thank you.
I know that when you gave this presentation at the VA, when they had a legislative, event for local government leaders, I think one of the issues were sometimes family members of elderly veterans don't know that they're eligible for benefits. And I think having this card with the proper documentation might determine that an elderly veteran may be eligible for some VA benefits that the family didn't know existed.
Yes, Mayor, and I think also too, just by definition with this identification card, I think one of the most important requirements, even aside from the card, is the recording of that DD-214, and that becomes such an access point for our veterans and their dependents to obtain valid services. And so we're going to press both simultaneously, because even for veterans that may not desire the identification card for whatever reason, we still would encourage them to come down to the office and record your DD-214s, if not for yourself, then for the benefit of your loved ones when you pass away. That way, your DD-214 can be quickly accessed so you can go ahead and start the process for a proper military burial.
Okay. All right. Thank you. And in addition to that, we appreciate your service to our government.
Thank you, Mayor.
So,
Thank
okay.
you.
All right. Thank you for coming.
Thank
You're
you.
welcome to stay for the rest of it, but you don't have to. Do we have any other visitors that would like to address council at this time about this or any other matters? This would be your time to come up and state your name and address for the record, and we would welcome you. Anyone wish to address council at this time? I'm sorry, I can't hear you. Can you come up to public? I'm sorry, I can't. I apologize.
She has a question about the food trucks.
The food trucks. This would be a time to ask a question about the food trucks. No, please come to the podium so the people at home can hear you. And so I need you to state your name and address for the record.
So Michelle Tucker, I live at 49 Ivanhoe. And I guess my first question is, the policy still under consideration, or has it already been finalized?
We are going to deal with that in our legislation tonight, but what we're planning on what we don't want to give it away, it's people watching this on television, but we're going to rescind the ordinance that we initiated at our last meeting. We're going to have a first reading of a new ordinance that would only allow food trucks after getting for a special event and only at the discretion of the city manager. So it's much more restrictive than what the original ordinance said. Did I say that accurately?
You stole my thunder.
It's not unfettered discretion of the city manager, but he would approve permits on
A specific event on a case, perhaps something like a block party or something like that. We might do
And
that.
that probably addresses my concerns.
I think it will. I know you sent us correspondence, I think.
I did. I
Yeah.
addressed correspondence. Because where I live,
Yes,
it's a huge concern.
yes. And so I think you'll be happy when you hear what we do tonight.
And
Okay.
I have scouts with me. I have Boy
I
Scouts
thought you had at least
101.
one, okay.
And they're fulfilling, part of the reason why they're here is they're working on their communications. Is it a merit badge? Merit badge.
And
And
s-
so we thought this was a great opportunity.
This will be an excellent
to,
one.
Kind of also address a topic that they're interested
Mm-hmm.
in and kind of familiar with, because we do love the food truck rallies, but to have one parked really like right at our front door would probably not be as ideal. So,
Right.
okay, well, great.
And do either of them wish to address council?
Alex, Marcus, you want to say hi? Hi.
There will be a test at the end of the council meeting. All right. Anyone else wish to address council? All right. We will close the visitor portion, and we will, in fact, get to our legislation. The first item Vice Mayor Byington has is an ordinance to consider some zoning code amendments regarding our various variance standards.
That is correct, Your Honor. This is an ordinance to repeal existing section 1006-7, the variance standards or the Oakwood zoning ordinances, and adopt a new section 1006.7, variance standards of the Oakwood zoning ordinance. This is an ordinance update to update the decision standards used by our Planning Commission and the Board of Zoning Appeal to evaluate zoning variances. It has been recommended by the City Law Director to align Oakwood's variance standards with the Ohio Supreme Court case law. As required by law, amendments to the text of the zoning ordinance require 2 public hearings. The first was held before the Planning Commission on June 6, 2018, and resulted in a unanimous recommendation of approval by the Planning Commission. The second public hearing will take place this evening. This is a first reading of this ordinance, so I'll not make a motion until the second reading of at the August 6th meeting. So I would turn this over to you to convene the public hearing, Your Honor.
Thank you, Vice Mayor Byington. I will now open up a public hearing for anyone that wishes to address council regarding this issue, regarding the changes to our zoning ordinance related to variances. Does anyone wish to address council on this meeting?
Before you take public testimony, I would request to give a staff report on the changes.
That would be outstanding. So that will put some clarity here that we can create some additional questions for the scouts at the end of the meeting.
Thank you, Mayor Duncan and members of council. What's before you, we're going to talk about tonight, are the variance standards, which is probably an area of our code that most residents either don't know about or pay very little attention to if they do know that it's in the code. But the variance standards are the decision standards that our Board of Zoning Appeals or our Planning Commission use when they're deciding whether to grant a variance from provisions in the zoning code. Perhaps you want to build a deck, and your code says you have to be 10 feet off your lot line with that deck, but because of the configuration of your lot, you need that to be within 8 feet of your lot line. You can come in, there's a process where someone can request a variance, and they can come in here and put on evidence and testimony and have that decided either by the Board of Zoning Appeals or the Planning Commission. Those decision standards that the Planning Commission and Board of Zoning Appeals use are what we're talking about tonight. You'll see on my slide, this is the nature of the application. This initiated as an application that was submitted for an amendment to the zoning code. That was a staff-initiated application. I'm going to talk to you a little bit about what it is we're trying to change and also about 2 key Ohio Supreme Court cases, Kissel versus Sandusky and Duncan versus Middlefield.
This isn't me, right?
I'm sorry?
This is not me, not this Duncan.
Not this Duncan.
Another
no.
Duncan, okay.
No, different
All right.
Duncan.
All right.
Probably a distant relative, though. And then we'll get into what the specific changes are to the ordinance that I proposed here. Specifically what we're going to do is we're going to replace an existing section of the code, 1006.7. Disregard my typo on that slide. What you have in your legislation is correct. It's going to eliminate 1006.7 and adopt a new 1006.7. It's a new set of standards. So I want to talk first about Kissel versus Sandusky. This is a 1984 Ohio Supreme Court case. So we're not talking about the bleeding edge of legal developments that are happening right now. This was many years ago in 1984. Kissel versus Sandusky was heard by the Ohio Supreme Court. Basic facts in that house are a guy named Kissel buys a single-family home. He wants to convert it to a duplex and rent it out. He's in a district that's zoned for 1 or 2 family homes, so that duplex would be a permitted use. but his lot size was below the minimum requirements for area and yard requirements for a duplex. He applied for a variance, and it was denied. And the reason that it was denied was that he knew about the zoning restriction before he purchased the property, and so they felt that he couldn't show that the zoning code created an unnecessary hardship on him, and they refused his variance. He went to court and sued, and after a lengthy appellate process, the court relied on a New York case, something called Hoffman versus Harris. There will not be a test on that. But what that New York court said was that when a variance is one of area only, there's no change in the character of the zone district, and the neighborhood considerations are not as strong as in a use variance. And so they decided that the standard for granting a variance which relates solely to area requirements should be this lesser standard than that applied to variances which relate to use. An application for a area variance need not establish unnecessary hardship. It is sufficient that the application show practical difficulties. So there's two things that are coming out of the Kissel case. One is this distinction between area and use variances. A use variance might be, I buy a piece of property in an area that's zoned for commercial, but I want to build a residential home there. It's not zoned for residential, it's zoned for commercial. I want a variance. It's kind of like a version of rezoning. That would be a use variance. In Oakwood, we don't allow use variances at all. We have specific zoned areas with permitted uses in each, and we don't allow use variances. What we do allow are this other kind called area variances, which is I want something a little taller than the code says, or a little closer to the property line than the code says, or there could be a variety of ways that this can come up. But they're things that have to do with quantitative and measurement kinds of specifications. The other thing that Kissel did was it talked about the two different standards. When you're talking about use variances, you use the unnecessary hardship standard. But when you're talking about area variances, you use this lesser practical difficulty standard. The other case I want to talk to you about is Duncan versus Middlefield. And you'll see from the date there, this was just a couple years after the Kissel versus Sandusky case. In this case, the facts aren't as important as they were in Kissel. This is a person who buys a single-family property, wants to expand it to an 8-unit multifamily, which was a permitted use there, but under the Middlefield code, he didn't have sufficient street frontage to enlarge it to an 8-unit building. He was denied his variance on unnecessary hardship grounds, but interestingly enough, when Middlefield took it to court, they defended on the practical difficulty grounds, even though that wasn't the standard they applied. Court ultimately agrees with Middlefield, but in getting to their decision, they laid out 7 specific factors. They decided what the test should be when you're trying to talk about practical difficulties and use that lesser standard. What should the board be considering? What are the factors that ought to be considered in reaching that decision? And they spelled them out in that case. They talked about the practical difficulties. The Duncan Court says, while existing definitions of practical difficulties are often nebulous, it can safely be said that a property owner encounters practical difficulties whenever an area zoning requirement, for example, frontage, setback, or height, unreasonably deprives him of a permitted use of his property. The key to this standard is whether the area zoning requirement, as applied to the property owner in question, is reasonable. They went on to say that the practical difficulty standard differs from unnecessary hardship standard normally applied in use variance cases because no single factor controls in a determination of practical difficulties. And I'll tell you a little more about what that means. A property owner is not denied the opportunity to establish practical difficulties, for example, simply because he purchased the property with knowledge of the zoning restriction. When we get into factors here, and no single factor is controlling, it's no longer the way it's currently structured in our code, which is the applicant has to show that they meet all of the following. And there's a laundry list of standards, and they have to meet each and every one, and if they miss any one, they're not entitled to the variance. What the courts are saying is, no, that's not the way to go about this analysis. There should be more of a weighing. And just because they can't meet one doesn't necessarily mean that that's determinative. It's a balancing and a weighing of competing interests. Key points from Duncan is the zoning requirement reasonable as applied to this property, this particular property under consideration? And then, of course, the factors that I was talking about. Let me go through what those factors are. These are the things that the court has told us that planning commissions and boards of zoning appeals are to consider. The first one is whether the property will yield a reasonable return or whether there can be any beneficial use of the property without the variance. Second one, whether the variance is substantial. Third, whether the essential character of the neighborhood would be substantially altered or whether adjoining properties would suffer a substantial detriment as a result of the variance. Number four, whether the variance would adversely affect the delivery of governmental services like water, sewer, garbage, and not listed there, but certainly other valid examples would be emergency services as well. Number five, whether the property owner purchased the property with knowledge of the zoning restriction. Again, that's not necessarily determinative. It's just one thing that can be considered by the board. Number six, whether the property owner's predicament feasibly can be obviated through some method other than a variance. And those are the court's words, not mine, but in other words, is there some other way of solving this problem other than granting a variance? Number seven, whether the spirit and intent behind the zoning requirement would be observed and substantial justice done by granting the variance. Spirit and intent is important, and that's a great factor for boards to use when they come in here. And if you've ever been in here when the Planning Commission or the Board of Zoning Appeals is hearing a case, they do this. They think about, well, why do we have this requirement? What's the purpose of the requirement? What's it designed to protect against or to encourage or to prohibit? And they get into looking at why do we have that in deciding these cases. That's exactly what this is asking them to do and will continue to do under the new code. The other thing I want to point out here is that this allows sort of an opening for substantial justice to be done, even though it may not meet the strict letter of the zoning code. The Duncan court talked about substantial justice in terms of the applicant. What does substantial justice to the applicant? But there have been some subsequent cases that say that substantial justice is about the applicant, but it also requires that you balance the interest of the community and the neighborhood that it's located in and the adjoining property owners. Everybody is given due consideration, and it's all about balancing those competing interests. So under these standards, that's exactly what we would ask the Board of Zoning Appeals and Planning Commission to do. And number 8 is a bonus factor, any other relevant factor. Now, the court specified 7, and then they said, plus they can consider anything else that's relevant. There may be something that's relevant in one case that isn't relevant in another case. That would come out through hearing the facts, and what this says is that the board is allowed to consider that. They are not necessarily limited to just the enumerated factors. Again, remember the key here is reasonableness. All right, we'll move ahead. What we're changing here with the ordinance. First of all, our code, when it talks about variances, uses the phrase unnecessary hardship or particular hardship over and over and over again. In actual practice, I think what the Planning Commission and Board of Zoning Appeals are actually doing is they're applying the practical difficulty standard, but that's not what it's called in our code. And when it comes to if we have a case that should ever go up on appeal and we're arguing about this in court, these phrases have legal meaning, and it's important that our code and that the standards that we use match what the case law out there talks about. Number 2, we'll replace the existing factors with the Duncan factors, and that's as simple as eliminating the old ones, adopting the new ones. Number 3, the changes that you have in front of you will eliminate the must-meet-all approach. That's when I talked about where currently you have to show that they meet every standard on the list in order to receive the variance. Instead of the must-meet-all approach, the new ordinance talks about the weighing and balancing and no one-factor controls. Number 4, there's some new material that I added in this ordinance. It's not clearly addressed in the code, and that is I've expressed a standard of review and a burden of proof. Those are just the standards that would apply when they're being heard here by the Planning Commission or the Board of Zoning Appeals. The standard review is that the review is to be based on the application, the staff report, and any relevant and credible public testimony and evidence that's presented. Most of us probably think that's common sense, but our code never said that. Now it will under this ordinance. And then with the burden of proof, the applicant is to show practical difficulties sufficient to grant the variance by a preponderance of reliable, probative, and substantial testimony and evidence. That's a fairly common civil standard that's applied, and we would use it in these cases as well. Important thing to remember about variances, variances are what give the city a relief valve from being sued. daily and often. And what I mean by that is, when you adopt a zoning code, you're adopting a blanket scheme to sort of overlay on a city that existed before that zoning was even adopted. We have a zoning code that attempts to specify how close this can be and how tall this can be and so on and so forth. We've tried to specify that across the board. But those parcels, we have parcels that are oddly shaped, oddly positioned, weird topography, you name it. People are going to have needs for variances, and by having a variance procedure in place that matches the case law, it's going to give us a defensible process when we end up going to the common pleas court on an appeal. What we're doing is we're avoiding the likelihood that a resident can't get a variance and says, your zoning code may be constitutional as to everybody else, but it's unconstitutional as you're applying it to my property because I can't comply with that. This variances give an out, and in this case, that out is overseen by the BZA and the Planning Commission. But it's an important part of the process. Like I said, it's not something that most people really think of a lot, but it is an important part of the process, and I hope that these changes will update our code and keep us moving forward. Do you have questions for me tonight regarding the ordinance?
I have one. Do we have any current Board of Zoning Appeals or Planning Commission cases going on currently that would be directly impacted by this change?
I do not believe that we have any pending cases at the moment. Am I correct? Yes.
Okay, that's what I thought, but I just wanted to make sure. And so you had answered my questions about I think we had maybe 10 standards before, and you're going to replace them with the 8, the 7 Duncans plus anything else, any other reasonable factor?
If you look at those 9 or 10 that we have currently, and you lay them out next to the 7 Duncan Factors, there's a lot of overlap.
Yes.
They're actually very similar.
Okay. And you're trying to comply with the Ohio Supreme Court rulings that are, to some extent it's housekeeping, but to another extent I think it's adding a little more clarity to our process.
Correct on both counts.
All right, thank you. Anybody else have questions? All right. Then, if anyone else wishes to address council, we're still in an open public hearing. If anybody in the audience had questions about our law director's presentation or has any other questions that council should consider before we rule on this, again, not tonight, but at our next meeting in August, this would be your time to come down and address council. Any of you scouts want to get into a legal argument with our law director? Okay. Any of you want to become a lawyer after hearing that? All right. Well, in this case, since we have no one else that wishes to address council, we will close the public hearing. And am I correct, Vice Mayor Byington, that you're making?
First reading,
as a
yes.
first reading, so we'll have a second reading at our August 6th meeting, and then the council will vote to approve or disapprove this change.
Yes.
All right. Thank you. So that's the first one. So your second one is another ordinance regarding zoning code amendments related to residential group rentals and family residential
That's correct.
uses.
And before I introduce this one, I wanted to defer to our law director to review some of the minor language revisions that we added for the purpose of clarification. This is a second reading, so this has already been introduced, so making a few changes requires that we acknowledge those changes for the record.
Is your mic on?
It is now.
All right.
I'm sorry, I was scrambling
Yes.
for paper once I got back to my seat. There were 2 changes that were made to this. Wait, I'm sorry. Which ordinance are you on at the moment?
We're on
the
the
ordinance.
residential rentals.
Okay.
Section 301.
Perfect. I just want to make sure
Yep.
I'm speaking to the right one. Made 2 changes to it. One is to correct a typo of mine. Throughout that ordinance, if you look at it, it talks about that it applies to single family and two family properties. There's one place in there that says single, 2, and multi. And that was a typo on my part. I've taken out multi to make sure that it's consistent.
A Scrivener's error.
A Scrivener's error, yes.
That was the word I was looking for, Councilmember Epley. Okay.
The other change that we made, which is relatively minor and not substantive, is that there is a provision in there that deals with individuals who have developmental disabilities or handicaps of some sort, and the Americans with Disabilities Act, and how that interacts with our residential group rental ordinance that's before you tonight. The changes that have been made to that were made at the urging of the Fair Housing Association here in Montgomery County, which we're going to be working with them on doing some additional disability-based legislation down the road a bit. But in the context of this one, the change that was made was simply to remove the number. We had said originally that supported living facilities or similar facilities that provide accommodations for up to 4 unrelated adults, at least 3 of which require personal care services, would be presumed to be a household that is the functional equivalent of a family. Simply taken out the number, the up to 4, and left it that any group of adults who have a handicap or disability as defined by the Fair Housing Act will be presumed to be a household that's the functional equivalent of a traditional family.
All right. Which essentially is de minimis. Is that your understanding of that change?
It is not a substantive change to the ordinance and
All
does
right.
not require us to go back and do a reintroduction with a new first reading.
All right, thank you. So, yes, and
I will continue,
go
yes.
ahead and please
I'll-
continue, Vice
yeah.
Chair Byington.
As I mentioned, this is the second reading of ordinance which we introduced that would amend existing section 301, which is the terms defined of the Oakwood zoning ordinance, to clarify certain definitions pertaining to residential uses and to adopt new section 409, which is residential group rentals of the Oakwood zoning ordinance. This ordinance is to update our zoning ordinances and is intended to accomplish 2 primary functions. First of all, it clarifies several definitions that pertain to residential land use. These are not substantive changes. They are merely intended to clear up wording that could be considered vague or ambiguous.
I'm sorry.
It also adds a new section to the zoning ordinance to address residential group rentals. The primary goal of this section is to adopt objective criteria by which the city's building commissioner can determine whether a group of people living together do or do not constitute a single family. The Planning Commission has already reviewed the proposed ordinance and held a public hearing on May 2nd, 2018. The Planning Commission unanimously recommended that council approve it. Council introduced this ordinance with a first reading and public hearing at our June 6th meeting. And as this is a second reading of the ordinance, I would move that council adopt it this evening.
Do we have a second?
Second?
Is there any other discussion for Vice Mayor Byington or questions? Hearing none, Lori, would you please call the roll?
Mayor Duncan?
Yes.
Vice Mayor Byington?
Yes.
Mr. Stevens?
Yes.
Mrs. Hilton?
Yes.
Mr. Epley?
Yes.
Thank you. And Vice Mayor Byington is still in charge here because he now wants to talk about mobile food trucks.
Food trucks, yes. This is an ordinance to establish procedures and standards for the operation of mobile food vehicles. 2 ordinances were introduced at our June 6th meeting to update the city's business regulation code with respect to food trucks. The first was an ordinance that will allow mobile food vehicles, or food trucks, to operate on public right-of-ways in the city. After we introduced that ordinance, we heard from a number of residents concerned about food trucks on residential streets, particularly near the school and public parks. For example, what if a vendor decides that a location in front of a particular house is a good business location, and they want to operate there every day for 1 hour at a time? Or if several food truck operators decide to surround Oakwood High School every day at lunchtime. The consistent theme we heard is that residents do not necessarily dislike food trucks, but they're concerned that the ordinance would create an open system that allows licensed vendors to decide when, where, and how often they will operate their business in the city. Council is receptive to and shares these legitimate concerns. For that reason, I'm withdrawing the original ordinance introduced last month. In its place, I'm introducing an alternate food truck. Oh, thank you very much. The lights help considerably. In its place, I'm introducing an alternate food truck ordinance that council asked the law director to prepare. This new ordinance will allow food truck operations in the city, but does so with an event-based permit system instead of the open system in the prior ordinance. This new ordinance includes a number of provisions to protect the residential character of our community. Highlights include the following. Permits are always required for food truck operation, whether on public or private property. Permits will only be issued in connection with a specific party, rally, or other event sponsored or hosted by an Oakwood property owner. There will be no blanket permits or annual licenses. Permits will be issued for a specific location during a specific time. All operators will be required to display their permit on the dashboard or hung from the rear view mirror during the permitted event. Permits will be issued on a first-come, first-served basis. No more than 3 permits will be available for a particular event, although the city manager will have limited discretion to increase the number of available permits for larger events in locations that can accommodate more food trucks. And also, the city retains the right to deny or impose conditions on permits as needed to minimize traffic and parking congestion, to protect public safety, to ensure that access to public buildings and facilities is not impeded, and to ensure that there is no interference with the delivery of governmental or emergency services. Now, provisions that were carried forward from the prior ordinance include all operators and facilities must be in full compliance with all state and county requirements for mobile food service and must have all necessary licenses, permits, certificates, and inspections. All operators and facilities must be in full compliance with all local ordinances, including the noise ordinance. Even with a permit, food trucks will be prohibited in alleys and on the following streets: Far Hills Avenue, Schroyer Road, Patterson Road, East and West Shantz Avenue between Oakwood Avenue and Oakwood Kettering corporate lines, the Oakwood Avenue between Far Hills and Irving Avenues, and Park Avenue between Far Hills and Harmon Avenue. Hours of operations are between 11 a.m. and 9 p.m., and unless being operated on a closed road, such as for a block party, food trucks must be parked by the curb, must dispense food curbside, and cannot impede the orderly flow of traffic around them. This is a first reading of this ordinance, so I'm not going to make any motion at this time.
Any questions for Vice Mayor Byington regarding this? So this ordinance is available, this revised ordinance is available. I would encourage citizens to look at it, and if they have any issues for council related to the revised ordinance, please let us know. Our plan would be to review this ordinance at our second reading, for a second reading in August 6th, and at that point, council will act on the ordinance, either for or against.
Yeah, as one of the reasons we do, and you'll probably notice, the reason we do a first and second reading is so that things that are brought forth have the opportunity for the public to review them and to provide comment. I know that almost all members of council have received some sort of comments, positive and negative, or more questioning in a lot of cases, and that a lot of the comments that we received were incorporated in coming up with this new piece of legislation. So, given that there's new information here, we encourage the public to review this ordinance and provide any input they might have.
All right, thank you. And then, because we had 2 ordinances for the food trucks the last time, you have a second ordinance regarding the street sales.
Yes, Your Honor. Let's see. Yeah, this was an ordinance to amend existing section 725-1, street sales prohibited except in the business district of the Oakwood Business Regulation Code, to create an exemption for the operation of licensed mobile food vehicles. This is an ordinance to update the building code regulations. However, since a new food truck ordinance was just introduced tonight, and will have its second reading at our August council meeting, I would like to make a procedural motion that council defer the second reading of this ordinance until August, so that we can read both of them at the same time. So I'll make that motion that we put this off for a month.
And that, your motion does require a second. Do I have a second?
Second.
All those in favor of approving this motion to defer it to the next meeting signify by saying aye. Aye. Thank you. So ordered. And then your last bit of legislation tonight is an ordinance regarding our property tax renewal levy.
Yes. This is an ordinance providing for an election of the question of a renewal tax levy in excess of the 10 mil limitation for current expenses and the general operation of the city. The city has an existing 3.75 mil property tax levy, first approved by Oakwood voters in 2013, that is due to expire at the end of 2018. At our June meeting, council took the first legislative steps to put this matter on the ballot for renewal, and this ordinance is the second and final step. It is important to note that since this is a renewal instead of a new levy, it will maintain the current levels of property taxation and will not increase property taxes. In order to meet the filing deadlines for the November ballot, I move that council waive the second reading on this particular one and adopt it this evening.
Do I have a second?
Second.
Any other comments for Vice Mayor Byington? Hearing none, Lori, would you please call the roll?
Mayor Duncan?
Yes.
Vice Mayor Byington?
Yes.
Mr. Stevens?
Yes.
Mrs. Hilton?
Yes.
Mr. Epley?
Yes.
Thank you. That concludes our legislation. And now for the highlight of our meeting, our new Director of Personnel and Properties, Jennifer Wilder, is here to give her introductory report to council. We welcome you, Jennifer.
Thank you. Thank you for the opportunity to address you this evening, Mayor, Council, staff, and residents of Oakwood. The following is a brief update on the activities of the Properties and Personnel Departments. And I will address for you tonight zoning and property maintenance, beautification, an update on the Vectron project, a brief update on development and business around town, personnel activities to date, and a few city events. First, just an introduction to the zoning department. The zoning department exists to protect Oakwood residents. As Montgomery County Recorder Brandon McLean stated earlier this evening, for most people, the biggest investment they'll make in their lifetime is the purchase of a home. By enforcing the zoning and property maintenance codes of the city of Oakwood, the city is working to protect residents' property value and the values of those properties around them. We do that by reviewing and analyzing land use, zoning proposals and requests, and administering permits for improvements residents would like to make to their property. Our number one goal is compliance with the council-approved Oakwood zoning codes and Oakwood property maintenance code. And just very quickly, an introduction of the people that residents would meet if they were to come into the zoning department. Lindsay Korn is our receptionist. She's the first smiling face residents encounter on the administration side of the building. Lindsay's been with this city just shy of 2 years and processes all building and zoning permits, schedules inspections, and answers a multitude of questions that residents may have about zoning regulations. Sherry Laidler is the department secretary and has been serving the community for over 10 years. Sherry wears many hats in her position and has a wealth of knowledge in zoning administration, seems to know every property in the city of Oakwood, and also supports the personnel department as well as facility maintenance of the beautiful city historical building. Lastly, Ethan Kroger is Oakwood's zoning and code enforcement officer and has served as such for the past 3 years. Our residents and businesses work with Ethan on a daily basis when they're looking to improve their property. Ethan's contact information is readily available on the city's website, and he's a wonderful resource of zoning and property maintenance information. And I encourage all residents to contact Ethan before taking any steps towards property improvement. Knowing Oakwood regulations ahead of time can certainly save residents some time in the long run. Ethan will even meet residents at their property and can walk them through the permitting process so they have a clear understanding of the outcome. As you can see from the numbers shown on the slide, the zoning department can be a busy place with almost 400 permits issued in 2017 and also almost 400 inspections completed as well. In addition to ongoing property maintenance efforts, the zoning department is responsible for a citywide automobile tour where we identify violations of the Oakwood Property Maintenance Code. Property owners are sent a letter advising them of the violation with a date established to complete the repair. The most common violations we've seen in the tour this year are dead or diseased trees and chipping or peeling paint. Although we give a deadline in the letter, the city also will work with property owners who require additional time to correct violations. We just request communication to that fact. And in the rare circumstance where there's no contact from the resident and there's no attempt to correct a violation, citations can be issued to appear in the Oakwood Municipal Court. As I mentioned, though, our goal is compliance and not citations. Speaking of communication with residents, I have on the image here for you, this is a yellow door hanger or tag. This is one of the many ways the city communicates with residents when there's a property concern, such as a tree that needs trimming, a yard that needs mowed, a vehicle issue, a sign issue, work being done without a permit, yard debris that might be placed in the street, or any other zoning or property maintenance concern. I do want to clarify for residents that this tag is not a citation, but rather it's the first step in communication. And it could potentially lead to a citation if the property maintenance concern is not corrected within the prescribed time frame. But at the very top of the tag, in this area right here, is the phone number and the name of the person that's leaving the tag. And if you receive a tag, I encourage you to contact the person that's left it. Typically, that's Mr. Kroger, myself, or potentially a refuse foreman. Let us know of your intentions regarding your property maintenance concern. And again, we just remind you that the zoning department exists to protect property values. Our goal is compliance with the code, not to issue a citation. One of the violations that we frequently encounter is the proper placement of yard debris. Oakwood ordinances prohibit the placement of any debris in city roadways, except for leaves, of course, in the 10-week fall leaf collection season. Debris of any sort, including yard waste, when it's placed into the street, including the gutter line along the curb, can cause safety issues. The debris can interfere with the flow of vehicles and bicycles, and it can be detrimental to the stormwater collection system. We offer several options for disposing of yard debris. A couple of the do-it-yourself options include dropping the yard debris in the dumpsters at the Krieger Field parking lot, which is open 24/7. Residents can bring it to the Fell Public Works Center at 210 Schaefer on the first Saturday of the month between 8 and noon, and there is a staff member there to assist people in removing the debris from their vehicle. And for larger yard projects, residents can call the Public Works Department for a dumpster to be delivered free of charge to their home. And again, the dumpster is free of charge if it's used exclusively for yard waste. The city does collect yard debris from property frontages on a monthly basis, January through September, and biweekly October through December. The collection dates are published in the Oakwood Scene and are posted on the Oakwood website. For city yard collection, yard debris should be placed off the street and just behind the curb, and ideally just a day or two ahead of the scheduled pickup date. Yard debris cannot be placed around trees, fire hydrants, cable boxes, posts, or poles in the street or gutter, and that's mainly because of the equipment that we use to pick that yard debris up. However, when yard debris is found to be in the street or gutter, the city will leave a yellow door hanger like I showed in the previous slide, and if the debris is not removed within the 72 hours noted on the tag, the Public Works Department will pick up the debris. However, they will charge the property owner with a special pickup. And as part of the city's refuse program, property owners are entitled to 2 free special pickups, and after that, they're billed at $100 each. And if anyone has any questions about yard debris, where to place it, or has a concern about yard debris on their street, please contact Code Enforcement Officer Ethan Kroger. Another code enforcement task is monitoring the city for sidewalk encroachments. Trees and other vegetation are an important part of Oakwood's ambiance, but proper maintenance is essential for reasons of public safety and community aesthetics. Code Enforcement Officer Ethan Kroger conducts citywide sidewalk inspections twice each year to identify locations where trees or vegetation are encroaching public sidewalks. What is an encroachment? Basically, if there's less than 8 feet of height clearance above the sidewalk, or if there's any material that breaks the vertical plane extending upward from either side of the sidewalk, or any point up to 8 feet, then the tree or vegetation would be considered encroachment. Why do we care about encroachments? Oakwood is a walkable and bikeable community, and sidewalk encroachments can force walkers and bikers into the street if they're not able to pass. What happens when Mr. Kroger sees an encroachment? If it's minor, like a branch or 2, he may trim it on the spot. If it's more significant, like that seen in the picture, then a yellow tag would be left at the address, requesting that the property owner remove the encroachment within 5 days. If it's not corrected within 5 days, Oakwood Public Works may be called in to trim, just depending on the severity of the encroachment, which of course can result in costs assessed to the property owner. Our ultimate goal is passable sidewalks for residents' enjoyment. I mentioned that we appreciate communication with our residents, and this is a very positive communication that should you receive a letter from the zoning department, the zoning department also administers the Oakwood Beautification Award Program. Protecting property values is our goal, and the beautification program allows the city to recognize residential, business, and rental property owners who have invested in their property by enhancing the beauty of Oakwood and making landscaping or building improvements. Properties are nominated by citizens or staff and are judged by members of the Oakwood Property Maintenance Board, and awards are given May through August and are publicized in the Oakwood Scene, on the city website, in the Oakwood Register, and also receive a sign in their yard during the month of their award. And recognition will be done at an Oakwood Council meeting this fall. Just a quick update on a project going on around town. Earlier this summer, Vectren and their subcontractors began a 3-month replacement project, which is the continuation of a multi-year Vectren infrastructure replacement project here in Oakwood. To date, this year, Vectren has replaced underground gas distribution pipes on Peach Orchard, Monterey, Hillview, and Triangle, and now replacing home service line on those same streets. Yard restorations in this area are also currently underway. The work along East Drive, on the East Drive project between Schaefer and Schroyer, involves the same construction as just mentioned and also includes the installation of a new 16-inch diameter primary gas supply line, replacing a line of equal size. In both areas, Vectren is moving indoor gas meters to outside wall locations. Vectren has been working hard to minimize construction impacts such as parking and traffic disruptions. On East Drive, the section from Schaefer to Hathaway has been completed, and work continues now in the next block. Asphalt roadway restoration will follow. Public Works Foreman Tom Long has been working alongside Vectren and their subcontractors to ensure the work is completed as safely and expeditiously as possible and with the least impact to Oakwood residents. Should residents have any questions or concerns about the work, I encourage them to contact the Public Works Department and speak to Tom Long. We appreciate the patience of Oakwood residents while these improvements continue this summer. A brief development update. Earlier this year, Hills Properties broke ground on the condo development known as Element Oakwood that will include 2 buildings housing 42 condos each. Hills development is currently in the foundation stage after spending additional time addressing drainage issues. The next steps include underground plumbing, and residents can expect to see framing up by late August. Just up the hill, before you on the slide is conceptual art of a revised Russell Wealth Management building. Russell Wealth Management received approval from Council in November 2017 to build a 22,000 square foot 3-story with walkout basement office building at Sugar Camp. Approval for the project lapsed as construction for the building did not commence within the required 6 months. Russell Wealth Management returned to the Planning Commission earlier this month to present a smaller office building, a 2-story, 16,600 square foot with no basement building, and has received Planning Commission's recommendation, which will be heard by Council at the August 6th Council meeting. A brief business update around town. In the Far Hills Business District, the 2600 Far Hills building, Kettering Health Network purchased the building in April of 2017, and while no building or zoning applications have been received to date, we understand the plans remain to establish medical offices there in the future. The Morning Sun Florist plans to occupy 2411 Far Hills, formerly known as Rife's Jewelers. Residents can expect to see upgrades in exterior finishes as shown in the picture on the slide, and as well as interior remodeling, and Morning Sun Florist plans to open in September. The Goodwill store located at 2322 Far Hills opened in December of 2017. While there have not been any parking issues since opening, in an effort to encourage patrons to use the parking lot located just to the south of the store, Goodwill will be placing a small sign on the building reminding patrons to utilize that south lot. And if you travel Far Hills often, then you may have noticed the awning sign on the Oakwood building was removed for a period of time while the building owner had repairs made to the building. The awning has since been restored to its original location. And then lastly, just as I mentioned in the previous slide, Russell Wealth Management plans to locate their headquarters at Sugar Camp. Personnel updates in 2018 include the following. Public Safety Officer Mike Russell retired April 15th with 25 years of service in public safety, and 18 of those here at the City of Oakwood. Public Safety Officer George Williams retired May 24th with 21 years of service in public safety, 7 of those here at the City of Oakwood. And new hires to date include Public Safety Officer Justin Sloan, who was hired on January 8th, Old River Maintenance Alex Schooler, who was hired on March 12th, Public Safety Officer Jesse Schaffer, who was hired on May 14th, Oakwood Community Center Receptionist Marvel Elsesser, who was hired June 30th, and Public Works General Service Worker Troy Gearhart, who was hired July 9th. Lastly, just a couple updates on local Oakwood events. The Oakwood Farmers Market is held weekly on Saturdays from 9 a.m. to 1 p.m. through October 20th, and it's located on Orchard Drive in the public lot just behind the Retail Business Center on Far Hills. More information, including vendors and special events, is available at oakwoodfarmersmarket.org or on the Oakwood Farmers Market Facebook page. As a free service to Oakwood citizens, the city has once again contracted with Shred-It to be on site at the Public Works Center on Saturday, September 29th from 8 to 11 a.m. to provide document destruction services. If residents have confidential papers or other material of a private nature stored at their home that they would like to have destroyed, we urge them to take advantage of this opportunity, and there will be individuals on hand to assist residents with unloading documents from their vehicle. Since the last Community Shred Day was held in 2017, the Oakwood Public Safety Department has installed a locked prescription drug drop-off box here in the lobby entrance at the city building located at 30 Park Avenue. This drop box offers a way for residents to conveniently dispose of unwanted or expired prescription drugs and is accessible to the public 24 hours a day, 7 days a week. With that, I conclude the update on the activities of the Personnel and Properties Departments. I'd like to thank city staff and council for their support during this transition in my new position here at the City of Oakwood. The City of Oakwood is a wonderful community. I am grateful that during my employment, I have been fortunate enough to witness daily examples of dedication to public service, which makes Oakwood a great place to live and work.
Well, thank you, Jennifer. I appreciate that. Does anyone have any questions for her?
I do. Jennifer, did you say the farm market goes till October 20th?
Yes.
Okay, that's huge. I mean, that's really different from other years, because I've heard from some of the vendors that they, the September, early September end date is really hard on them, because that's when that's when they have their best produce. So that's great. And then for the property maintenance, do you use any of the citizen committees to drive around or to report?
Yes. The
Okay.
Property Maintenance Board sometimes submits complaints that they may see out walking or,
Okay.
or driving, so we do receive complaints that way. We receive a lot of call-in, a lot of emails anonymously from our website, but yes, there are multiple ways to receive complaints, not just from code enforcement, Kroger, out seeing those.
Okay. Do they get assigned like a precinct, or it's just if they see
They
it?
do. There are 5 districts in the property.
Oh,
maintenance
okay,
board.
okay. Cool. Okay, thank you.
Any other questions? All right, well, we appreciate having you here. You, big shoes to fill, but with Jay leaving after 35 years, I think it was.
At 35. yes.
35, and so we did find him. He is back in town. I took him golfing here about a week or so ago, so it wasn't pretty scores, but we had a great time. But thank you, Jennifer.
Thank you.
All right. So now it's time for our city manager's report. Mr. Klops.
Thank you, Your Honor. Just a couple of comments. I'll react to Jennifer here. It's hard to believe she's been here 5 months, and she talks as if she fully understands Oakwood, and I can tell you, she talked about kind of being a sponge on a daily basis, and I've witnessed that, and she's done a great job in learning our city very, very quickly. You remember she came here from the city of Centerville, where she worked for 14 years, and I think she's probably as well-versed in Oakwood now, on Oakwood, as she ever was on Centerville. So we're real happy to have Jennifer here. And also, Ethan is here tonight, and he has really stepped up and taken a leadership role in the Planning Commission meetings and the BZA meetings, and is just doing an outstanding job for the city. So thank you, Ethan, for all you do. And while I'm reporting positive news here, 2 days from today at 2:30, Wednesday, the Auditor of State will be here in council chambers to present to Cindy Stafford, who is also here tonight, the annual Auditor of State Award for Excellence in Financial Reporting. So that basically means that we once again had a clean audit here, and last time I checked, about 8% of the jurisdictions in the state of Ohio are recognized with this Auditor of State Award, so it's not handed out regularly. So it's really something that we ought to be proud of, and Cindy does the heavy lifting, as you know, when it comes to leading our finance department and making sure that everything we do is done by the book, and every dollar is accounted for. So I know 3 of you can be here on Wednesday, and again, that's a wonderful event, 2:30 here in the council chambers. Jennifer mentioned construction. We've got, of course, all the veteran work, which there is a lot of it going on, but we've got
really in many different areas of Oakwood now, different construction activity. Down where I live on the north end, a contractor for AT&T is putting in communications lines. Our sidewalk curb and apron project is well underway in the Wilshire, Corona, Hadley area. Working south, we're beginning tomorrow, going to do some quick curb repair work on West Hadley and also on Acorn. This is in preparation for the asphalt mill and overlay that's coming. And that work is now scheduled to begin this Friday. The contractor will work on Saturday and again on Monday and maybe Tuesday. And if all goes well and the weather holds up, you know, they could be in and out of here in less than a week, which would be fantastic. So all the property owners involved on those mill and overlay streets received a letter from the city now about 3 months ago with some advanced notice about the project. And then last week, we mailed postcards. This is a reminder of the work coming, and Tom Long is overseeing that work as well. The work at the tennis court is progressing nicely. We have a ribbon cutting, kind of grand opening ceremony tentatively set for 5 p.m. on Monday, August 20th, and that'll be heavily attended, hopefully, by representatives from the Oakwood schools and in particular our boys and girls high school tennis team. So we'll confirm that date and time as we get a little bit closer to it, but hopefully, again, a lot depends on weather, but we should be on track for that event. And that's all I have tonight.
Any questions for our city manager? Hearing none, it's now time for council comments. Councilmember Epley.
Thank you, Mayor. I have no comments tonight.
All righty. Councilmember Hilton.
Your Honor, I have no comments tonight.
Councilmember Stevens.
I just want to congratulate Jennifer on her first presentation. Very thorough and informative. Thank you for being efficient and not keeping us till 10 p.m. Wonderful presentation. Thank you. I really did enjoy that. Thank you.
Vice Mayor Byington.
No comments this evening.
Well, I have an hour and a half speech I'd like to now issue. No, okay, we won't do that.
And meeting is adjourned.
I do want to send a shout out to our sister city, La Visenay, France, a suburb of Paris, as the French national team won the World Cup. The last time they did that was in 1998, and they had one of their players, I cannot pronounce his last name, but I think it's Mbappé. He's the first person that made a goal in the World Cup since Pele in 1986. So I think the French team has a lot to look forward to. So, and I don't have to watch the World Cup for 4 more years. So with that, our next meeting is on August 6th, 2018. We are in fact adjourned.